understandings rather about what a will does and what a trust does and who needs what and kind of when you're properly using each tool. We're also going to talk a lot about on kind of the 4 main documents that every estate plan should have, whether or not you're using a will or a trust. Everybody needs these documents, anybody over the age of 18. So we've talked a lot about that in the past, and it's a really important topic. So hopefully you guys find this very interesting today. But we'll be talking about that, and then also a few other topics that we have coming up in the next couple of weeks. So again, welcome. I'm Justin Randall. I'm an attorney with Hooper Law Office. So we are here to talk today about wills and trusts and sort of the main estate planning documents that you need. Just a quick reminder, when we sent out some to people who pre-registered, we did send out some materials for you. So we have this Hooper Law Office document finder. So if you keep your will in a certain place, or your documents after powers of attorney, things like that in a certain place, that's a really good place to fill it out so that people can find it. And excuse me, you'll get those after the session. We'll be sending those out after the session for those of you who registered. And another thing too is just kind of a brief year-by-year list of the major changes with estate planning documents and estate planning laws, or laws that affected estate planning over the past. It goes back to 1986, so at least 34 years, right? So another thing I just want to mention is we are sending out some evaluation forms. If you could please take the time to fill those out. It just tells us how we're doing, and if there's any topics or anything like that you'd be interested in hearing, it gives us some ideas of what to talk about with you guys in the future. And there is also a place on those evaluation forms for if you would like us to reach out to you and like to discuss things further, we'd be happy to do that. We don't reach out to you unless you ask us to. So it's completely up to you, but it does help us either way if you fill out the evaluation side of things. And we also do have the ability for you, those of you who registered through Zoom, there is a Q&A function, and you can actually ask me questions if anything comes to mind. And I'll see them, and I'll get to them and answer them right here and now if I can. So yeah, please use that if you have any questions. Well, why don't we get started? So to start with, really the big misunderstanding of when you have a will or you have a trust, the big misunderstanding people have is what those documents actually do. The biggest misconception people have with wills is that, oh, well, I have a will, so I'm not going to go through probate. Everything is set up so that I don't go through probate. My will took care of that. Well, the problem is, though, is that wills are actually an instruction to a probate court of how you want your assets divided up. So what that really means is that your will only controls the assets that go through the probate system, not any assets that go outside of the probate system. So if you have beneficiary designations on accounts, if you have transfer on death, payable on death, things like that, those are going to go directly to the person you've listed, or the individual or organization that you listed, depending on if it's a charity. Those don't go through probate, which means that your will, if you have certain designations in there dealing with those distributions, those are not going to control. So it's really important that you know what your estate plan does in order to make sure that you're using it properly. But before I get too much into that, I want to cover a couple key documents that, regardless of whether you have a will or a trust, that you'll really want to have. I mean, they're essential to have. The first is a financial power of attorney. So a financial power of attorney is a document in which you are naming someone else as somebody who can step in and help make financial decisions for you, should you not be able to do so yourself. A lot of times they're set up so that power is immediately effective, meaning you don't have to be declared incapacitated for that person to step in and help you. It can be a really beneficial tool to use even if you have full capacity. What you usually see in a financial power of attorney is things like writing checks, paying bills, going to the bank, opening and closing accounts, things like that. But the problem is that a financial power of attorney is only really as good as the authorities that are listed in it. So a lot of times what I see is, maybe the state statutory form that you can download online, or, some other law offices kind of documents sometimes where they're not very clear on what those authorities are. It may say things like, I grant banking or, real estate powers to so-and-so. But what that means is completely open to interpretation. You're not saying what banking powers means. You're not saying what real estate powers means. You might be able to infer a lot of things from that, but whether or not that would be enforceable because it doesn't explicitly say it would be really up in the air. So what you really want to see in a financial power of attorney is not just banking powers, but my power of attorney agent has the ability to write checks, the ability to open and close bank accounts, to pay bills, to file my taxes, very explicit, very well explained powers. One of the most important things that I often don't see in financial powers of attorney is the ability for your financial power of attorney agent to plan for long-term care for you if you've lost the capacity to do so yourself. So that is not, an authority where it says, oh, they can do long-term care planning. It'll be a collection of powers that allows us to do long-term care planning. But more than I care to have seen, more times than I care to have seen, people have come in where somebody has been declared incapacitated, and they, when you sit down and talk to them, they definitely don't have the legal capacity to sign anything either. And their financial power of attorney doesn't give the authorities we need to actually protect assets from long-term care expenses. So it's really heartbreaking, but there's not really a lot you can do in that instance where I don't have the authority and neither does that power of attorney agent. So it's really important to make sure you have all of the authorities that you really need and may need at some point in that financial power of attorney. When you're picking an agent, one of the most important things to kind of keep in mind is not necessarily, my son's a CPA or a financial advisor. I mean, that can be helpful, certainly, but it's not the most important thing. The most important thing when picking somebody is, hey, are they going to pay my bills on time? And are they responsible? Are they going to do it in a timely manner? Are they not going to just go, make bad decisions with my money, things like that? That's really the biggest consideration. Obviously, if you don't trust somebody, don't give them all of that authority. That's a terrible idea. You are granting a lot of authority with that document. So you do need to be careful about who you name. But yeah, really, I don't care if somebody knows how to play the stock market or anything like that. And actually, and so I did just get a question. So right about financial powers of attorney. So yeah, again, everybody can send those in. So the question is, can I have a primary power of a financial or primary power of attorney agent with a second choice if they cannot fulfill it? Yes, I would often recommend, or almost always certainly say, have backups in place. What we usually do is it's, so-and-so first, and then however many people as backups should they not be able to fulfill that role. So if they become incapacitated themselves, if they passed away, whatever reason they might not be able to act. Sometimes too with financial powers of attorney, if you trust people equally, you can have multiple agents at the same time with independent authority. So if you love all three of your kids equally and they're all equally responsible, maybe all three of them can act together. That's not a big deal. It's pretty easy to do for financial powers of attorney. So yes, there's a lot of, you definitely want backups. I wouldn't just ever pick one and then, leave it open-ended after that, because you're not really protecting yourself should something happen to that agent either. Location, I should say, location doesn't really matter. A lot of this stuff can be online, done over the phone. It's really, if your kid lives in Seattle and you live in, Maine, that person could still be a perfectly valid financial power of attorney for you. It's really not a big deal. It can certainly help if they're close by, but it's not really the biggest concern. So those are kind of the big things with financial powers of attorney. Like I said, you really want to make sure that it has all the authorities you need in it and that it is, you have the right people in place for it. The next document here is a healthcare power of attorney. So a lot like the financial power of attorney, you're granting some authority to someone to help make health decisions for you rather than financial decisions. This is really important to make sure that you have in place as well, because this is what's going to allow people to make healthcare decisions for you, treatment decisions, and potentially end-of-life decisions for you, should they need to make those decisions. So having this in place really gives them the authority they need to make those decisions about, maybe where you receive care, what hospital, things like that, or can they help get you into a nursing facility if need be. Those types of things are really, really key to have in those documents. Unfortunately, with a healthcare power of attorney, you can't have those co-agents like that. You can have an order. It's just you can't have multiple people acting at any given time. It does, the statutes do say it has to be an individual, singular, not plural. So there can be an order, but it can't be all kids at once, because I mean, you think about it, you don't really want multiple people fighting over healthcare decisions when it's essential that a decision be made. And I should mention too, with both finance and healthcare, you're not giving any authority away. You're not, nobody can override you with those powers of attorney. You are simply sharing that authority, or kind of duplicating your own authority, so that someone else can step in and fulfill that role should you need them to. No one, by granting a power of attorney, is saying, I'm giving you my rights, I don't have any anymore. That's not how those work. That's a different situation entirely, and a different legal process. But so just so you know, you don't have to worry about, oh, my son or daughter can tell me what to do now. That's not what that means. Kind of going along with the healthcare power of attorney is a HIPAA authorization. So I'm sure many of you are familiar with HIPAA at this point. It's really just a document that says, okay, this list of people can talk to the doctor on my behalf. The doctor can talk to them and tell them what's going on. This is a really important document to have for anybody, honestly, even people who are 18, because what can happen is even to an 18-year-old, say, somebody who's just in college, something happens to them, they're in the hospital. If you don't have a HIPAA authorization in place saying, oh, my parents can talk to the doctor on my behalf, or the doctor can talk to my parents, they may not be able to figure out what's going on if there's an accident or if something happens. And, unfortunately, this has happened before. This is coming from a real example, not just a hypothetical. So you really want to make sure 18 and up, you have all these powers of attorney, HIPAA authorization in place. And I should say, a good healthcare power of attorney document will also include a HIPAA authorization in it, because you obviously need your healthcare agents to be able to talk to the doctor. If they can't, what's the point? But we do both. We have it in the healthcare power of attorney and as a separate document as well, just to definitely double up on it. It doesn't hurt. The last of the 4 key documents is a living will. So a living will is not a last will and testament. It's not where you're saying, here's where I want things to go. A living will is saying, if I'm on life support or in a terminally ill condition, do I want to be maintained in that condition, or do I want to be removed? So if you don't want to be maintained on life support, it's really important that you state that intention in a living will, because it gives people that clear instruction of, here's what I want should this happen. Now, again, the healthcare power of attorney agent is the one, along with your attending physician, who has to agree on that. So it's important to make sure that anybody you pick as a healthcare power of attorney will be able to make that decision. The last thing you want is somebody who you've trusted to make healthcare decisions your whole life suddenly say, I can't do this. I'm going to keep them on life support. I just can't do it. It's too hard. So having the discussion with them is really important verbally, not just them reading a piece of paper at the time. So yeah, I always recommend people actually talk with their agents and say, hey, if it comes to this, could you do this for me? You're not making the decision for me. You're just following my wishes. And the living will really provides them some liability protection there too, so that if they make that decision, nobody can go against them and say, oh, you took mom and dad off life support, I'm going to sue you. That's, you made a horrible decision and you're completely at fault. That's not what, if you have the proper documents in place, they have some protection from that. They're just following your wishes. So those are kind of the 4 ones. Whether you have a will or a trust, you need those documents. Any estate plan without them is just not complete, because it's also about taking care of you while you are, while you're still living, but maybe are incapacitated. So the question we get a lot is, okay, I was the power of attorney for finance for my mom or my dad, and they've just passed away. Can I start paying off bills, going to the bank, start distributing the money, things like that? And unfortunately, the answer is no. If you are a power of attorney for somebody, but are not the executor in their will, or are not the trustee of their trust, powers of attorney all end at death. They don't go beyond that point. So if you are the financial power of attorney for somebody, but not the executor or not the trustee of their trust, you don't have the authority to make those decisions anymore. That authority stopped. So it's really important to know what role you play beyond that point too. I often will recommend that you have the same people as financial powers of attorney in the same order that you would have as as trustees or as personal representatives or executors, if that makes sense to do that, because then you don't have to remember, you just know what order you're in. But it's important to know that you're no longer acting as a power of attorney at that point. You may be acting in another role. And before I go too much into wills, I do want to say too, what happens if you don't have powers of attorney or healthcare powers of attorney in place and someone needs to make decisions for you? Unfortunately, the only way then, if you don't have these signed and in place and can't sign new ones, the only option they have is guardianship, which is a process where your family or somebody petitions the court for guardianship over you in order to be able to make those decisions. And that is always, always have powers of attorney as a first resort. You don't want to rely on guardianship, because what guardianship is you're actually selecting rights over those people. So whereas a power of attorney is merely granting someone the ability to share your authority, a guardianship is really more of, okay, you no longer have that right to make that decision. The guardian of you does now. So it's always ideal to try to avoid that if you can. There are perfectly valid reasons to be going through guardianship if somebody is causing financial harm to themselves or something like that. Obviously, no power of attorney in the world is going to stop them from having the authority over their own finances. So then maybe a guardianship is necessary. But I wouldn't ever hope for that to be someone's first line of defense on it. And the problem with guardianship is no court in the world is going to grant your agents the ability to protect things for long-term care expenses. So it's really important to make sure that you have a good power of attorney for finance drafted before you ever get to that point. So onto wills, that's where, if you're named as a personal representative or executor, they're the same thing in Wisconsin. It's just Wisconsin calls them personal representatives. So that's how you get authority over those finances after someone's passed away. But it's not an immediate thing. So with wills, you have to first receive what's called a domiciliary letter from the court, which is essentially your proof, your little slip of paper you can show to the bank and say, yes, I'm the executor. Yes, I can act on behalf of the estate. That process is not immediate. It does take a little bit of time to get in place because you have to submit the will first to the probate court, get approved, get that domiciliary letter. Everyone who's an interested party, essentially somebody who may be inheriting or would inherit if there was no will, they have to sign off on it, making sure that, I'm fine with that appointment. So when you name someone as a personal representative, you're not guaranteeing that that person is actually going to be named in that role. You're merely making a suggestion to the court. They weigh that suggestion very heavily, but they may or may not be named in that role if somebody has a very valid reason why they shouldn't be. So after that domiciliary letter is in place, that's when that person can go act. And again, like I said, though, what they may find is that they still don't have power over everything, because if they are the executor of the estate and all of the finances avoided probate because they had a payable on death or a transfer on death designation on them, those are not going to be subject to the provisions in the will, and therefore not subject to the authority of probate or the personal representative potentially. So it can really make things out of alignment and really make it hard for them to administer the estate effectively if all of the finances avoided probate, but the only place they have that authority is over the probate estate. What you often see, for example, is the home goes through probate and none of the finances do. So how does that personal representative pay for the ongoing expenses of the probate estate or the expenses of the home? Things like that. You're not giving them what they need to do their job effectively. And that's not to say everything should go through probate, but you want to make sure it's well thought out what does and what doesn't when you have a will. There are some things like IRAs, things like that you may want to avoid probate because of certain penalties that can occur with those types of accounts. So that's the biggest concern with wills I see, is people have them and think, I'm set, I'm going to avoid probate, or they have a will and say, well, okay, it doesn't control everything that, all my assets are avoiding probate with beneficiary designations. Well, the question is then is why are you using a will at all? If you're not using the right tool for what your goals are, it's like using a hammer to try to screw in a screw. It's just not the right tool for the job. It's going to end up in some messy results probably. But you also don't want to over rely on beneficiary designations. Beneficiary designations are certainly good tools to use in the right circumstances, but they are not an estate plan themselves. The reason is it's not a centralized point of control for anything. I mean, you have to have a beneficiary designation on every account. And if it's my whole estate goes 50-50 to my kids, you better make sure that all of those accounts are designated that way. And what happens if something goes wrong and that company changes hands, right? And now maybe the beneficiary designation didn't carry over, or you forgot to update it when you made changes to what your intentions were. It's just very easy for things to get out of alignment when you have to go to a dozen different accounts to make sure everything is updated all the time the right way. The other problem with beneficiary designations is those designations pay out or transfer directly to the name of, or to the ownership of the people named on as beneficiaries. This can be a huge problem for certain people, especially if they have any creditor issues, are right in the middle of a divorce, or are getting sued for some reason, or are on any sort of means-tested government program like Medicaid or SSI. Well, if that money just goes to them in their name, which is what happens most of the time with beneficiary designations, those people are going to be potentially harmed because of it, because now that money is not going to just them. It may be subject to creditor claims, or it may kick them off of their benefits. For some people, the benefits they're receiving too are not just monetary benefits, but people like children with special needs. Sometimes it's the caretaker they have or the programs they're a part of, and you don't want to cause them harm by trying to do the right thing, but not doing it properly. So beneficiary designations, you do need to be careful with naming individuals if they have any of those concerns. And that doesn't mean you have to disinherit them and not leave anything to them. It's just that there are provisions that you can put in either a will or a trust that would take care of them there and protect them from harm there. So it's really important to make sure that you're not just leaving money to somebody that, may not be benefited in the long run by receiving it. If it causes them more harm than good, you didn't really help them all that much by leaving them that money. So it's better to do it the right way. So how do you avoid the probate then and not and still kind of have a plan in place that controls everything? And that's where trusts are the better option. If your goal is to avoid probate, but you still want to plan, a trust is a good option. Because trusts don't go through probate. So anything that a trust owns when you pass away does not go through the probate system. The probate court does not have any jurisdiction over it. It's a completely privately administered thing. The other thing too is that it's still a central plan. Your trust says, here's how things get divided up when I pass away. Here's the specific distribution I want to go to this charity. And you don't have to remember, what the beneficiary on each and every account was. The other thing with a trust where I find it to be a little more beneficial than going through probate with a will is that a trustee, your successor trustee of your trust, the person who takes over after you've passed away, that provides them a much more immediate access to those finances and to that control over those accounts to begin paying expenses if they need to, because they don't have to be approved by any court. You've approved them by naming them. It's a matter of, what does the document say? So if, Johnny is my backup trustee and I pass away, Johnny becomes the trustee and he gets to administer the trust as defined by what I've set up. I don't have to wait for a court to sign off on it or for interested parties to approve any of it. That is who is named. The other benefit of a trust is it's a completely private proceeding, assuming nobody sues anybody, right? If it's administered outside of any court, there's no access to that document. So you don't have greedy beneficiaries or potentially disinherited beneficiaries from coming forward and saying, show me the document. Whereas with a will, one of the big concerns is that if it's submitted to the probate court, that becomes public record. Anybody can go look that up. So wills can be completely public record. And for some people, that's not a big concern. But especially if you have minor beneficiaries, that can be a really big problem of, oh, that's where you get some of these like predatory, investors who are coming in and saying, oh, I can help you deal with your $1 million inheritance from your parents. And then they just, essentially steal from them. I mean, it's not a good thing in those circumstances, certainly, to necessarily have all of the finances subject to probate court if you have really small minors that you don't want to necessarily have public record. And I don't mean to knock on probate too much. I mean, there are perfectly valid reasons to use it. The only place you can name guardians for minor children is in a will. So that is one reason to go through, have at least something go through the probate system. Even if you have a trust, you have to name guardians in the will. It doesn't mean you don't also have a trust, but that is where you have to name those guardians for minors. The other thing too is there are certain types of planning for married couples who are doing long-term care planning where you have to do it through a will. So there are reasons why you might need to use a will over a trust too. Neither is necessarily better than the other. It's just you want to use the right tool for you. And if you don't have a lot of those concerns and you don't have a lot of worries about long-term care or anything like that, you don't have minor kids, that you need to name as guardians or name guardians for, I should say, a trust is probably going to be the better option for you, but it ultimately depends. Whether you're using a will or a trust, one of the most important things to talk about is that you can set things up for your beneficiaries that protect them from the kind of how we say it, protect them from themselves and protect them from other people. So what I mean by that is I mentioned earlier, creditors, they might be in the middle of a bankruptcy. They might be sued for some reason or getting a divorce or, receiving Medicaid or whatever it might be. When you have someone inherit the right way through either a will or a trust, you can set up asset protection for them for what they receive. It's obviously not bulletproof. I mean, there are ways to mess it up, certainly, but you're providing them a lot more protection over those assets they've received from you than any money they will ever have in their own name, because it's how they inherit. The provisions in their inheritance dictate what those protections are. So that's the divorce lawsuit and creditor protection that I was talking about earlier. But I also mentioned protecting them from themselves. And that is where things like somebody's completely irresponsible. They're never going to be responsible with money. They're just going to spend it down, or they don't have any money in their own name. It's really important to know that you can put someone else in control of that if it's ultimately necessary. You can make sure that it gets stretched out and provides for them if that's what your wishes are. Underage people is, they're a good example of this. And I say underage, I mean maybe underage of what you've determined. So you can fully inherit at 18. You can own that property, but no 18-year-old in the world should be in charge of potentially, $1 million. That's just asking for disaster potentially. So what we often do is we put an age limit on things where it says, okay, you can inherit at 18, certainly, and somebody can use that money for your benefit, but you are not going to be in control of it until you're 25, 30. You can technically go as old as you want with it. But usually around 25, 30 is for kind of somebody who's otherwise responsible. It makes sure that by 25 or by 30, you hope they're responsible enough to handle that money and make their own decisions with it. You can also protect what you're leaving them for your grandkids too. So if you really don't like someone's spouse, you don't like your son or daughters, you don't like your in-laws, you can say, I'm sorry, you can't leave it to that person, or, somebody else is in control. It has to go to my grandkids. It can't go to Susie or whatever his or her name might be that you don't like. So you can really place a lot of control over things like that too. So like I said, I mean, whether you use a will or a trust, you want to use the right tool for you and you want to actually use it. So with a trust, just like a will only controls what goes through probate, a trust only controls what it owns. So if you have all of your assets outside of the trust and they're not designated to the trust at the very least, after you pass away, your trust won't do you any good either. So an unfunded trust is as bad as a will that has none of the assets going through probate. They're just not being used. So whatever the right tool for you is, use it. You don't want to pay me money to set something up for you and then you never use it. At that point, why'd you pay me anything? It didn't do you any good. I didn't do you any good by not, having the right documents in place for you either. So, that's why here we talk through with everybody of what their goals are, what do you want to see happen after you're gone, and we can usually make a really good recommendation by the end of our meeting, our initial meeting, to say, hey, here's what we think is probably what would be best for you. And it's always up to you to go forward, obviously, if that's what you'd like to do, but we can give you a pretty good recommendation. So on that same topic, again, those evaluation forms that we'll be sending out, they do provide a way for you to send it back to us and say, hey, I would like to set up an initial consultation, or some things were brought up that I'd like to get some more information about. So if anything I said today raised some red flags or concerned you in any way about your situation and you'd like to talk to us about it, those initial consultations we offer are complimentary. They don't cost you anything to come in and talk to us. We can't know what's right for you if we don't talk to you first. So it's really important that you feel comfortable coming in and talking to us without worrying about what the fee might be for that meeting. You're just sitting down and talking with us. So we do have webinar or web chats available, phone conferences available right now, just given everything going on. So those options are available. But again, please send it back to us, and if you'd like us to reach out to you. And I hope to see you guys at our upcoming series. We have kind of control and aging in the aging process for our next couple of webinars. So how do you maintain control over your finances, I believe, is the next one. And how do you maintain control over your healthcare decisions as you age. So those kind of our care and aging and maintaining control are our next series of webinars, and we do them every Wednesday at noon. So please feel free to register, and I hope to see you guys then.